Democrats and Republicans alike have played the gay rights card when it suited them and dropped it when it didn't. 10, 15 years ago, Hillary Clinton and Barack Obama are both on camera opposing same-sex marriage. And then magically all of a sudden, they had a change of heart. Politicians don't change their mind. They change who they pander to. I'm here because I care about equality under the law, not as a slogan, but as a matter of contract, adoption, hospital access, taxes, estates. Call it marriage, call it a civil union, call it a domestic partnership. I don't care. What matters is that if I choose to share my life with someone, that the government recognizes that partnership the same way it would yours. That's it. That brings us to Kim Davis, the former Kentucky county clerk whose refusal to issue marriage licenses to same-sex couples after Obergefell v. Hodges made her a martyr to some and a symbol of hypocrisy to others. Now, nearly 10 years later, she's back in headlines because her case is up for possible review by the Supreme Court. Possible. So, to understand what's at stake, you have to understand a doctrine called qualified immunity. It's a legal shield meant to protect government officials from being personally sued when they're doing their job, unless they violate a clearly established constitutional right that any reasonable official should have known about. What does that have to do with Kim Davis? The fact that you're answering that question means that you have been misled. So, in 2015, if you didn't know, the Supreme Court had already ruled in Obergefell that same-sex marriage is a constitutional right. Okay? She wasn't confused about the law. She disagreed with it and refused to follow it. As a county clerk, she acted under the color of law, using the authority of the state to deny people licenses that they were legally entitled to. Qualified immunity doesn't protect defiance. It protects discretion. The Sixth Circuit Court recognized that, denied her immunity, and she's been fighting it ever since. Now, she's asking the Supreme Court not just to restore her immunity, but to reopen the entire conversation around Obergefell itself. If the court takes it up, it is not about marriage licenses anymore. It's about whether public officials can use their personal religion to refuse lawful duties. And that has massive ripple effects if overturned. Because if a clerk can deny a license, then a hospital clerk could deny a medical proxy. A benefits administrator can deny spousal coverage. A tax preparer or county assessor could deny joint filings. A probate officer could deny state rights or adoption paperwork. It's not theoretical. It's procedural. And the collapse of procedure is how equal rights die quietly, one form at a time. Like I said, you don't need to call it marriage. You just have to recognize that two consenting adults merging their households deserve equal standing under the law. That's not radical. That's the baseline for a functioning civil society. Honestly. The Kim Davis case isn't about religion. It's about responsibility. If you swear an oath to serve the public, you don't get to choose which public you serve. And if the Supreme Court decides to revisit this case, we should all pay attention. Not because of what it means for same-sex couples alone, but because It'll show us how far the law can bend before equality becomes optional paperwork. I'm Gray Ledger, and this was the Ledger Brief.